Yeah, absolutely. All right, Sean, we're going to let you go so you can go on back up there. And Sean makes a really good point about timing of this. And because it is such a high profile case, you would think that if the judge gets the signal from the jury, they would make sure that if family members did want to be present for the opening and the reading of that verdict, that they would give them time to be there. So we're going to have to see how this all plays out. All right, well, Sean we've been talking about the two questions that came from the jury yesterday afternoon. And I want to go over those because, again, and we'll maybe get a little perspective and expertise on what this could mean about what the jury is considering. But let's go ahead and take a look at the first question that the jury asked yesterday at about this time. They asked if there were two different ways that we can conclude involuntary manslaughter. And the answer from the judge was yes, there are two ways. They have to determine, and it's two theories by the prosecution. One, that Jennifer Crumbley failed to perform a legal duty, or two, she was grossly negligent, and they can find one or the other, and that would still trigger a guilty verdict for involuntary manslaughter. All right, let's go ahead and take a look at the second question that came from the jury then about an hour later, and this was yesterday, of course, but they asked, can we infer anything from evidence for witnesses that the prosecution did not bring, specifically not bring in the shooter or other people who can answer how he specifically got the gun? And in this case, the judge actually brought the jury into the courtroom to address them and then point to a specific place in her jury instructions and saying, no, you can't infer anything. You can't infer anything from evidence that wasn't presented. You can only judge this case on the witness testimony that was put in front of you and also the exhibits that were put into evidence. So then they went back in and deliberated until about 4:45 yesterday afternoon. And of course, Sean said they were in there at 9 o'clock this morning. All right, we know that you have a lot of opinions about this case. I feel like my social media feed is split down the line 50-50, adamantly guilty or adamantly not guilty. And you also still have a lot of questions. And as we walk through this together, it's good to get some expertise. So I'd love to bring in Jeff Swartz. He is a former prosecutor, criminal defense attorney, and county court judge, and he is a professor at Cooley Law School. Jeff, it's great to have you with me. So appreciate it. Good to see you.
Good to see you too. Thanks for having me.
All right, let's get down to it. As a former defense attorney watching this, you've got a jury in deliberations day 2. What does that signal to you from the jury, or can you give us any thoughts?
Well, first of all, I think the first question really shows that they're trying to plow through the evidence and trying to make a determination as to what facts they can agree upon and then move forward with applying those facts to the law. That seems to be the issue because they're saying, do we have two different theories? So now we have to make two different sets of facts or a set of facts that fits one or the other. The idea of inferring at some point the evidence they didn't hear. In other words, they can't create evidence and say this is what it would have been. However, a jury can consider, and they're told to consider, the evidence or the lack thereof. And if they think there's some evidence that if she were guilty, they should have heard, or if she was innocent, should have been or not guilty, should have been presented, then they can in fact consider the fact that either side or both failed to put on evidence that they wanted to hear and determine whether without it they can still reach a verdict.
Let me ask you a little procedural thing, Jeff. You know, we had thought that maybe we would see the judge come in this morning, bring the jury in, and then send them on their way to deliberations. That wasn't the case. They came in and they went directly to work. That's pretty much how it's done. And if this goes into a third day, that's what we can expect as well?
Correct. What happens is that the judge is doing other work. They have other work to do. And bringing them in and taking a look at them and all the things that go with it takes them away from the group deliberation and involves the court. So what they tell them is report back to the jury deliberation room. They're counted. If somebody's missing, the bailiff will say, we're missing someone. If everybody's there, the door will be closed. Someone will be there guarding the door, and the judge will be advised everybody's present and they are deliberating.
All right, Jeff, I want to go back to the two theories that the prosecution has put forth in this case for the jury to consider involuntary manslaughter. You know, one, that she failed to perform a legal duty, and two, that she was grossly negligent. Can you just explain for us legally again what those two things are?
Sure. One definition of voluntary manslaughter requires that the defendant have a legal duty to society, for lack of a better way to put it. And that duty has to be established either by law in the past or by statute. And so therefore you have a duty to act, and your failure to act is a breach of that duty. And the breach of that duty is considered reasonable or unreasonable by society. And that lack of doing that duty was a direct causation of the harm that was done to the victim. That really doesn't apply here because there was no legal duty on the Crumbleys to secure the weapon in a way that the prosecution thinks it should have been. That now exists, but it didn't exist when this happened. So therefore, that theory is just not going to work to substantiate a conviction in this case. The other side is that she could have done one simple thing that would have avoided the harm to the other person. And therefore, by not doing that one simple thing to avoid that harm, that person is grossly negligent because it was a known act that they could have performed. I still, again, have a problem with that as a defense attorney and even as a prosecutor. But I think if there's going to be a guilty verdict, it's going to be under that theory.
All right, let's go ahead, and I want to bring to you some questions from our viewers because, again, so many people are trying to follow this, and we do the service of being able to bring them the trial in real time, and they can stream it and watch it. But again, we're not the attorneys here, and we can all kind of get our own legal theories here. But I want to go to Sandra's question from Farmington Hills, and she wrote us that reports say that Jennifer Crumbley could be sentenced, if she's convicted, up to 15 years in prison for involuntary manslaughter. I thought that it was 15 years for each of the 4 counts. Could you please clarify that? Are we thinking this is concurrent?
Sure, it is 15 years for each count. The counts can be run consecutive and or concurrent. I don't know where this judge will go. I have an idea, but I really don't know. That would be pretty severe to sentence Mrs. Crumbley to 60 years. That's basically a life sentence for her. I think that that's a bit much. She might stack 2 of them and run the other 2 concurrent. I don't know what she's going to do, but yes, it's 15 years per count, and they can be stacked one on top of the other.
All right, Jeff, let me ask you this. We're going to go to another question from Eleanor, and this was her question. She says, I'm wondering how long it will take the jury to make their decision. Is there a time limit on how long deliberations can go on?
There's actually no time limit. Actually, the jury decides when time is up. They will either return a verdict or eventually, if they are hung, they'll come out at least one time and say, Judge, we can't reach a verdict. We think we're hung. The judge will give them what's known as an Allen charge, a way to try to break the block in trying to reach a verdict. And if they then cannot reach a verdict, the judge will declare that there is a mistrial, a hung jury, and the case will have to be retried.
All right, as someone who has practiced law for many years and is now teaching it, you must all be sitting around and watching for the potential precedent in this case. Give us your thoughts on that, and what are some of the conversations that you're having with colleagues?
Well, it kind of is breaking, and like you said, about half and half. We talk as lawyers. There are some lawyers who are sitting there saying this isn't going to be that bad a precedent because Michigan has passed a statute which deals with guns and securing guns. The problem is that if they go under the second theory, that is that there was an easy fix and she was grossly negligent for not doing that easy fix, the question now comes in is to, can you limit that verdict and the precedent it may set if in fact the conviction is affirmed to only guns? I don't think it can be done that way. My personal opinion is that now parents are going to have to worry about everything in their home that could be used as a weapon that they're going to have to keep away from their kids, even into when they become teenagers. For example, and I've used this, if you've got a kid who plays baseball and you've got baseball bats in your garage, and he gets into an argument with somebody, gets mad and comes home and gets a baseball bat and beats some other kid's head in, the question is, should you have secured those baseball bats? Should you have secured your kitchen knives? Should you have secured your landscaping shears? All of these can be weapons. How far are we going to go? And there seems to be no end to the examples that I could give you. So I'm concerned about the precedent it's setting that will spread and become far broader than it is now. And other states could take this as persuasive precedent to do the same thing in their states.
Yeah, I know a lot of parents are talking about this and responsibility. All right, Jeff Schwartz from Cooley Law School, really appreciate your time and expertise on this. We're going to be calling on you again as we continue to watch this. What's one thing, before I let you go, that we should be, I guess, watching with a critical eye in terms of how deliberations go forward from now and when they eventually do come to a verdict?
You can take a look at additional questions. Those usually give a hint as to where they are and where in their deliberations and what decisions they're actually having a problem interpreting the instructions or what the evidence was in applying the law to that evidence. So some questions will help you. The first question that they ask does help you. They are centering on issues related to the two different theories and whether the evidence is sufficient for it. I think that's a hint. You're not going to get anything from a bailiff who's standing there and can hear all of this. That could get him in a lot of trouble, or her in a lot of trouble. So I don't think that's really going to happen. I know everybody wants to know, what do you know? What do you know? And the answer is, I don't know anything. And that's basically what everybody should be saying. So we won't know anything until some questions come out, or whether we hear anything from them that shows that there is a real open dispute between the jurors.
All right, Jeff Schwartz, sounds so good. Thanks so much for joining me, and we'll talk to you soon.
Thank you.
All right, as we continue here on jury deliberations day 2, we go ahead and give you a live look inside the courtroom up there in Pontiac right now. We have not heard any questions yet from the jury on this second day, but we will be right back with our continuing coverage of Jennifer Crumbley's involuntary manslaughter trial. Stay with me.